now case number PD-0186-24, the State of Texas versus Justin Heath Pettit.
Presiding Judge Keller, counsel, may it please the court.
You're very soft-spoken. Will you speak up, please?
I surely will.
Yes.
Thank you.
Presiding Judge Keller.
Good.
Counsel, may it please the court. My name is Amy Blalock. I'm an attorney in Tyler, Texas, which is Smith County, Texas. And I'm here today representing Mr. Justin Pettit. I'm his attorney. Mr. Pettit is the petitioner here today. He was the appellee in the 12th and defendant in the trial court. This case today presents a very, I think, narrow issue, a legally discrete is what I'm calling it, issue of whether a passenger in an automobile has the standing to contest his seizure and to contest and try to suppress the fruits of that seizure, which is the evidence used to prosecute him. The 12th just found that this was a standing issue and said that he did not have standing, effectively, ending his appeal. This is a traffic stop case, and I know the court is aware of the facts. Mr. Pettit was a passenger in a vehicle driven by a lady named Bridget Tobler. They were out in Smith County, rural area in the eastern part of the county near the Gregg County line. This was on July 4th of 2019. It was 10:30 in the morning. It's a rural area, not a particularly crime area or anything, just a rural road. Mr. Pettit is a motorcycle mechanic, and he was riding with his friend, and they passed on this rural road a trooper, and they were not speeding at the time they passed, but the trooper found in his rear radar that they had begun to accelerate. This was an area, there was no speed limit signs. The nearest speed limit sign was about a mile away. And they were going about 45 when they passed, not speeding, and then they briefly accelerated, on the road. So the officer turned around and pursued them. There was no, they didn't flee. They pulled into a driveway, a driveway. There was no shoulder on the road. They pulled into a driveway of what was maybe an abandoned house, not a great house.
I thought the trooper had made a point of saying that they didn't pull off to the right, and it struck him as odd that they pulled off to the left when the law requires them to pull off to the right. But you're saying there's no shoulder on the road. Right,
that's right. And that was in the judge's findings of facts, that she did not find that a particularly compelling reason to give suspicion. They did pull over pretty quickly. And
Counsel, is this a case where we need to harmonize Lewis and Cothe, or get rid of Lewis in favor of Cothe? What is the rule for standing for a passenger in a vehicle that you are advocating for?
Yes, Your Honor, we advocate that a passenger in the vehicle has standing to contest his illegal seizure.
When? I mean,
When the fruits of that seizure are used to prosecute him. There's no need to find, the 12th court seemed to conflate search of the vehicle. And this is not what we advocated for. It's his seizure. Mm-hmm. That's the illegality, is his seizure on the side of the road when he was held, in this case, for approximately an hour. That's where he has that standing. And I know that both sides argued the Cothe case, if I'm saying that correctly. And Cothe was a little bit different because he was the driver of the car, and they searched his passenger. And this court found that he had standing because that was a seizure. And there were things found on the passenger in that vehicle. And they ultimately found that the detention, or there was not a prolonged detention, and this court held that the prosecution could go forward.
What makes the passenger seized in this case?
By being held on the side of the road. He was not free to leave.
Okay.
And that's where he has an expectation of privacy and not being seized that way that society is prepared to recognize as legitimate.
What's the alternative in a case like that where the driver is legitimately being held, the passenger's there, and they are in the middle of nowhere?
Well, they could wander off into the swamps of Smith County. I mean, he does not free to leave. He was, I don't know if he's even from this area. So he's held, and they've not written the citation. There's nowhere for him to go. There's no option for him but to be seized, and they're asking him questions. this entire time. They're saying, oh, you got any warrants, and do you have drug use, what's your criminal history? They are actively engaging with him. It's
Counsel.
not where,
Yeah, this is not a situation though we're not here to decide whether or not, it may very well be possible, and the state may have very good arguments as why this detention could have been prolonged. We're not here to determine why it should have been prolonged or if it should have been prolonged, if that's okay. We're just here to determine whether or not the passenger had the standing to contest the search.
that is correct, Your Honor. The 12th never reached that issue.
Okay.
And that's what we would ask this court to send it back for that consideration once it's established that Mr. Pettit did have standing, because they did not reach that issue. That's very, very clear. So that's why I think it's a narrow issue.
How does your argument square with the Supreme Court's opinion in Rakes?
Well, I think that Rakes helps us, Your Honor, because one of the things that Rakes said was that, that I really like about Rakes, and maybe I'm reading it wrong, but that the courts have to be aware that we don't get too caught up in like what they called arcane distinctions of tort law and property law to rule on Fourth Amendment issues. And that's what I like to take away from Rakes, is that this is a constitutional query, a Fourth Amendment query, and to look at it from that perspective, and to look at it from that perspective of whether he is being seized and whether his Fourth Amendment right has been violated.
Well, I mean, I know you're arguing that he's detained, and I take it, and what I'm seeing is that your argument is he's detained because the driver of the car is detained and the car is detained, and so therefore he's detained. That's sort of, is that it? Or
No.
is there, I mean, the officer asked him some questions, but the officer did not search his pocket for the tools. So I'm trying to figure out what else should lead us to the conclusion that he was detained.
Well, Your Honor, he was not free to leave. There had been no, they had him, they were asking him engaging questions, and with the passenger, I mean, with the driver. Like, these stories are not, they're not matching, or I find them, unreasonable. She doesn't really know him. He doesn't know her. There was active engagement, and he was not free to leave.
Did they do a pat down of the appellant?
No, he did not let them search he had some tools in his pockets, and so they asked for consent. They asked Ms. Tobler for consent to search the car, and she refused as well. So there's no searching, and the trooper even said to his partner, which is on the video, that he didn't think he had reasonable suspicion to keep them.
But was there any exploitation? Let's assume, for the sake of argument, then that your client was detained. Then was the discovery of the items that were found in the vehicle a result of the exploitation of that detention?
Yes, it was, because there would have been no search unless they were held there. The officer had to hold them there for that hour. It took the drug dog to get there. So that's how they found the evidence, and it's the firearm that's the subject of this prosecution.
Well, let's assume then, for the sake of argument, that there's really not sufficient reasonable suspicion to continue the detention of the passenger. If we find that there was sufficient reasonable suspicion to continue the detention of the driver and the vehicle, is that enough? Is your client out of luck?
No, Your Honor, I don't believe so, because he was being held. I don't think we're there, though, at this. I think he was being held, and that's a great query, but I don't think in this situation he was being held, and because they were.
I mean, what was the officer supposed to do? Offer him a ride?
Well, you had to let them go. He didn't have reasonable suspicion for either one of them.
But my point is, if he had reasonable suspicion with regard to the driver or to the vehicle, then would that be enough to justify the continued detention of your client?
Your Honor, I honestly don't think so, because I think that it becomes.
But then what was the officer supposed to do vis-a-vis your client
Well,
he had legal justification?
He could have said, "You're free to go. Can you call a friend to come get you? I'm going to hold her." He could have. There could have been an affirmative, release of him. Yeah, could you have a friend? Because I'm going to hold her. I don't like this car. She's tags out or whatever. Can you call and somebody come get you, or you want to walk away, or what? You're going to let him go. He did not.
Into the swamps of Smith County.
I'm actually putting the Fifth Circuit on a case we had in Beaumont, but yeah, into the dry lands or wetlands of eastern Smith County. Not a lot out there in that area.
So is there any opinion that you think, are we gonna have to overrule anything if we found in favor of your client?
No,
Or nobody has spoken on this particular question
Right.
before?
I think the federal cases have spoken on a little bit more aggressively, but this court, I don't think you have to overrule anyone but the 12th. I think this court's precedent, Cothey, it's not outlandish to say a passenger has standing to contest an illegal detention, a prolonged detention, and contest the fruits of that search.
But the Court of Appeals relied on Lewis, though.
Yes.
So you don't think Lewis is at risk if we agree with your argument?
I don't think so, Your Honor. I don't think you have to overrule it. But I think in this case, I think it's just looking at the facts of this case, it does not require that. And I would, always proceed with caution when I ask you to overrule something. But I think this is more in line with this court's opinion in Cothey, if I'm saying that correctly. But yes, that would be in line with that. And I think you're just asking to overrule the 12th. So my yellow light's on if there's no further questions.
Thank you, counsel.
Good morning. My name is Michael West. I represent the state of Texas in this case. First, I'd like to throw a little kink in this proceedings as far as the standing question, because I was sitting here last night in my hotel room, and it was late at night. I'm trying to think of what can I say, what the words to come to me, and suddenly a shaft of light came down from the ceiling, and the chorus of angels was singing, and lo and behold, the light landed on King versus State. And that's a case out of this court just from last year, where the question was standing. The facts of that case were somewhat different. I didn't run across it because I was so focused on passengers. But in King versus State, which is 670 Southwest 3rd, 653, incidentally, that case came down 2 days before the suppression hearing in this case. And in King, there was a truck driver who had been arrested, and the evidence showed that at various times when he's on the road, he's actually living in his truck. And of course, unquestionable standing in those situations is just set home away from home. But what happened was, when he was arrested, they searched his vehicle and they inadvertently left his cell phone in the vehicle. And a couple days later, 3 or 4 days later, the officers asked to have the phone returned to them, and that was the point in which the seizure occurred of the cell phone, and they got a warrant and whatnot. The question was whether he had standing at that time when the cell phone was seized to attack the search. And this court, 8 members of this court, decided that the standing takes place at the time of the seizure. But more importantly, I noticed in this case was that the court said at the hearing on the suppression motion that you have to present some evidence that you have this standing. It's an individual right, belongs to you under the Fourth Amendment, but if you want to assert that right, you have to establish standing, and you can't just rely on your motion to suppress. You have to present evidence showing you have a reasonable expectation of privacy. And in this particular case, in Mr. Pettit's attorney did not present a single witness. His cross-examinations were primarily concerned with questioning the recollection of the officer, but no testimony was offered to establish that he had a reasonable expectation of privacy as a passenger in that vehicle. And in fact, during cross-examination of the trooper, his attorney went to special pains to try to ask the trooper, what is it that ties my defendant to that backpack where the shotgun was found? And just based on the standing question as it was presented in King, there's no evidence. He hasn't met his burden initially to
If
even...
I'm remembering King correctly, though, the truck had been returned to the owner of the truck by the time they realized that they had left the phone behind. I mean, that's a different situation entirely.
It's a different situation, but it's still the same right. It's still the same expectation of privacy that you have to establish your burden. And the facts are going to change, But you have to come into court, if you want to complain about a search, come into court with some facts to show the court, this is why I had a reasonable expectation of privacy.
Well, why isn't that we wouldn't just analogize the passenger to the cell phone at the time that the car was seized? I mean, essentially the car was seized if the defendant or the passenger or the appellant is sort of like an article in the car. Isn't he seized as part of the car, the stop of the car?
And that's why he has a right to challenge the stop. Under the law, a passenger does have a right to challenge the stop of the vehicle. And in this particular case, he's complaining about a continued detention. But if you look at the record and watch the video, these officers were going about it in a very professional manner. In fact, within 11 minutes of stopping the vehicle, they decided to call the drug dog. And during that time, what they were doing during that 11 minutes was everything the law allowed. Obtain ID, run criminal histories, ask questions about criminal history. And then after they got that information, and under the facts of this case, both of the people involved, both the driver and the passenger, had drug histories. They had.
That's getting beyond the standing question, isn't it? So if he has standing to contest the stop, the initial stop, why doesn't he also have standing to contest the continued detention of the car and him there at the scene?
Well, because the courts have said that the standing question to attack the stop is based on his individual right to freedom of movement and things of that nature. So when you stop the vehicle, you interfere with that right. So you have the right as a passenger to argue that, hey, you interfered with my personal right to remain free and undetained. But once you get to that point where you've got to point to and standing to attack a search, you've got to establish a reasonable expectation of privacy. So you've got that.
Lengthy detention has nothing to do with his right to standing?
Well,
Yeah.
that's my fallback position would be that under the record of this case, there's plenty of evidence to establish that there was a reasonable suspicion to detain him. But as far as standing goes, according to Lewis, and I'd like to say according to King versus State, since he didn't meet his burden, but according to Lewis, you've got to have an exploitation of an illegal search or detention to be able to establish standing to attack whatever evidence was seized. And in this
So
case,
what do you make of the officer's comments on the video that they didn't have reasonable suspicion?
well, it's funny because when I saw that question, I thought, oh no. But then the officer said, well, I changed my mind. My actions show you I changed my mind. Yes, I felt that way, but he also testified once I ran that criminal history and I found out that he had lied to us because he asked the defendant specifically, have you ever been arrested? And the defendant was on probation for unlawful use of a motor vehicle, and he said he'd been arrested for DWI, and the trooper specifically asked him anything else, and he said no. And then he gets into his vehicle to run criminal history, and it turns out he's got 2 drug arrests within the last 2 years before the stop that he didn't tell him about. And the trooper testified, that was the final straw for me. This traffic stop is over now. Now we're talking about calling a drug dog. I've got reasonable suspicion. And he also involved in these facts are the defendant not testified, but told the officer when asked that he had a girlfriend, someone very close to him, who used hard drugs, and that he used marijuana.
But we're still talking about standing, so I want to ask you, how do you reconcile Lewis with Brenlin? The Lewis case with the Brenlin case out of the U.S. Supreme Court?
Well, Lewis, the standing in Lewis was all predicated on the exploitation of the stop, which was found to be illegal detention. But the court also said you have to show that somehow had an impact on the search to establish your standing. And in Lewis, they said that he could have walked away. The defendant could have walked away, and it wouldn't have made a difference, because the officer had the right to search at the time. And it's the same thing in this case, because before they called for the drug dog, that defendant could have walked away because once they decided to call for the drug dog, that was the case. And the defendant, you can see him on video smoking a cigarette, sitting on the ground, casually flicking a syringe into the woods. He just, at that point, the search was basically, this is the case. You have, I'm trying to verbalize this.
Well, let me ask it this way. So
Okay.
Brenlin, if I understand it correctly, said that a passenger has standing to contest a seizure of a car. The passenger can say, oh, this stop, I have standing to contest the validity of this stop. So why wouldn't he also have standing to contest the prolonged detention of the car he was riding in?
Well, basically, because the law says that. The Supreme Court has said you have standing to challenge the stop because it's an interference with your right to liberty and your freedom of movement. But once you get to a point where you're talking about a search of a place or a thing, you have to show you had a reasonable expectation of privacy in that place. And there's no evidence of that in this case. It's just the opposite. If you look at, let me find that case.
So I guess you just would limit Brenlin to the stop itself, the initial stop, and it has no bearing on the prolonged detention. Is that your position?
Well, for one reason, they didn't challenge the stop in this case. The only thing they challenged was the prolonged detention. The stop in this case was based on 3 traffic violations, and so.
Right. But Brenlin would give you standing for a stop, and you're saying it would not apply to the prolonged detention. Is that what you're saying?
Basically, yes.
Okay.
But you're also saying that he wasn't detained.
I'm sorry?
You're also saying that the defendant was not detained, right?
Well.
He wasn't told he could leave, but he wasn't told he could go.
Before they made the decision to call for the drug dogs, they were in basically a Terry stop situation. And the officers were performing their jobs, their duties, the way the law allows them to. And he wasn't detained until at that point where the officers decided to call for the drug dog. Then they said, the process of writing traffic citations is over now. We're now into the phase of investigation where we think we have reasonable suspicion that there may be something illegal in this vehicle. But up until that point, he was just temporarily detained. I would guess it's how it's described as a Terry stop.
Is there any distinction between standing as a principle of law and the reasonable expectation of privacy? I mean, are those essentially, are they necessary components of the same thing, or are they things that you can separate? Because I think I hear you suggesting that maybe we should treat them as separate things.
Reasonable expectation of privacy is the test for standing. And if you have a reasonable expectation of privacy and it's one side, society is willing to accept as reasonable, then once you establish that, you do have standing to contest a search. That's been the law since Rackus, even. And it's, in this case, there's no evidence, number one, that he had any reasonable expectation of privacy. And secondly, he never claimed to have an interest in the vehicle. It wasn't his vehicle. The driver didn't even know his full name. And he didn't have any dominion or control over the place.
So my next question is, why does a driver of a vehicle who's stopped on traffic, why does that person have a right not to be detained any longer than is necessary for the officer to dispose of his ordinary duties?
Well, I think it's because there's a legitimate interest in the government being able to enforce the law, protect society, and you cannot get a search warrant before you stop a vehicle.
No,
you have to
my
react
question
to the
is
facts.
about what is the source of this right to not have a detention go on for some period of time beyond what's necessary to issue a traffic citation, for example? What is the source of
I
that?
think it's a permutation sort of your Fourth Amendment right to be free from illegal searches and seizures.
It's the
And,
seizure right?
yes, sir.
So it's about seizure, and I'm wondering does this case turn at all on the distinction between a right against seizure versus a right against search?
I don't think so, because the differences between the two are well established under the law. Your right to not be, the right against being seized or stopped, I guess, is, as a passenger, if you're talking about a passenger, as a driver, I guess it's the same interest. Essentially, it's your right to be free from intrusion from the government, interfering with your life, and pulling you over to stop you for some reason. Now, the right to be free from detention, I guess that comes along after they've already established the reasonable suspicion. I'm not sure I understand your question, to be honest with you.
Yeah. Well,
Counsel, do we know who actually owned the backpack and the shotgun? Was there anything that,
I'm sorry, I don't.
do we know who owned the shotgun?
We don't know who owned the shotgun, and the shotgun was found in a backpack in the car in the back seat, and the only tie to the shotgun that is available under the facts of this case is that there were syringes found in the backpack and in the car that were similar to the syringe the defendant flicked off into the woods that the officers recovered later, and he never asserted an interest in the backpack. So that would be the evidence that ties him to it initially. And of course, that's a question for a jury or a judge once it gets to trial, whether there's sufficient connection between the two. But as far as standing, he didn't declare any interest in the backpack at all.
So the syringes were similar, the ones in the backpack, to the ones that he had in the woods?
Yes, sir.
Okay. So if it's his backpack, wouldn't you assume he has a reasonable expectation of privacy in the sawed-off shotgun that's in the backpack?
Well, you'd have to assume that because they didn't put on any evidence that he did have a reasonable expectation of privacy anywhere in the vehicle or in the vehicle itself. So it would just depend on the facts of the case.
I thought I heard you say a little while ago that, or maybe it was Ms. Blalock, that suggested that his counsel tried to establish that he didn't have, that he wasn't connected
That
to
was me,
the
yes.
backpack. Yeah.
In cross-examination, it's page 67, 69 in a motion for a suppression hearing. He asked the officer several times, what is it that ties the defendant to this backpack? And to me, that establishes that he's lacking, his attorney is trying to establish a lack of reasonable expectation of privacy in that backpack, because if there's no tie to it, then what expectation would society feel was reasonable in a backpack you claim no ownership of, in a vehicle you do not own? And to me, that, yes, he did, the defense attorney did do that, but to me it shows a lack of expectation of privacy in the backpack. And that's all I have, unless there's any other questions.
Okay, thank you,
For
counsel.
these reasons and the reasons cited in my brief, I'd ask the court to affirm the 12th court's opinion, and thank you.
Thank you, counsel.
To me, it's always a bit of a conundrum when the state wants to argue it's either standing or sufficiency of the evidence in this case. Do you have enough interest to challenge it, or do you have enough ties to prove your sufficiency? But that's I guess, a decision or discussion for another day. My friend Mr. West brought up the issue of King versus State, and that in King, there was a finding that there was no standing because the lack of possessory interest in the items. But I think I'd like to respond back to that this is another case where it's items to be searched, possessory interest in items. And this car had been returned, and the items were what was the subject of the lack of standing. And that he did, and I've mentioned that we don't want to get too caught up in, this is not a case where we're talking about items, we're talking about the seizure. And that's what gives Mr. Pettit the standing in this case. And I know that King was also, Mr. West talked about the burden of proof wasn't met because you have to have testimony that there is an interest in, where's your privacy interest? And our response to that is that the state established that when the trooper testified that Mr. Pettit was held by the side of the road for an hour, approximately an hour.
So counsel,
That's the
here's my question. It seems like your biggest complaint is not the detention of your client, but the detention of the driver, right? Like
No.
Well, but if you let's just say, the minute the car gets stopped and the trooper gets out and says, let's say the trooper said to your client, "You're free to go," and then does everything else the way it went down, they still find the backpack and then the shotgun. I mean, I guess that's my question is where, I mean, you're talking about sufficiency, and that's obviously an issue for another day, but they're still gonna find the items in the car. So, I mean, isn't the bigger problem for you not necessarily the detention of your client, but the detention of the car and the driver?
They're both a problem, but he's detained, and that's his right. He was held on the side of the road.
No, I understand that, but the discovery of the evidence of the backpack and the shotgun aren't necessarily related to the detention of your client, right?
I would disagree with that, Your Honor, respectfully, that he was held, and because he was held, and because there was questioning going on with both of these individuals, and their answers, were found to be somewhat, that he didn't know her, she didn't know him, he didn't know her, they were dependent on each other, they were interdependent, that detention was critical, his detention was critical. They had to wait there while he called the drug dog, and it was his answers that the officer felt like that he wasn't being truthful. That's why they held him there, that he wasn't completely forthcoming on his prior criminal history, although he did tell them some of it, but he didn't, he has had other arrests or, other problems with the law.
Did your client testify at the hearing?
No, the testimony was by the...
I'm curious, it seems like from most of the cases I've read around this area, there's a suggestion that it's the defendant's burden. Am I misreading that? To demonstrate standing?
It is the defendant's burden, and we believe that it was met in this case by the officer's testimony that he was held.
But did he say he was held? Did he use that word, I was holding him? Or did he say I detained him? Or did he say anything that directly would allow a reasonable inference that he was detained based upon some description he gave?
Well, he testified that they were held there and the length of the detention, and that he was questioning both of them during the time that they were held.
I remember the part about the questioning. I'm trying to figure out if you know where, what record-based testimony suggests that he said they were held, right?
Yes, I mean, there was a video introduced,
Right. Yes, but
and
that's not somebody saying I held him. That's a video showing that the car gets pulled over, right?
But wasn't there testimony about the length of time it took to get the dog and,
yes,
But even that goes to, it seems to me, the length of the detention, but not necessarily to whether the defendant could not leave, right? Because that's the ultimate question in deciding whether he was detained, was whether he was free to leave.
that's
And
right.
I mean, the fact that he didn't exert that opportunity alone, I don't know if that's sufficient to show that he couldn't, right?
Well, I don't think it was a reasonable, I think if he had gotten up and walked off, the officer might have had something to say about that.
Well, if he did, then we would know, right?
Right.
Then we would know that he was
Right,
detained
but
and he wasn't free to leave.
I think a reasonable person would have felt like they would have been detained. And Your Honor, I think it's important to remember that standing was not raised at the trial court. I think everybody assumed that Mr. Pettit had standing. This was an issue that was raised at the 12th. So I think everybody was
But
assuming.
again, it's the defendant's burden, right?
That's right, and we
So-
believe that we've met that. When it's the burden, it is the burden, of course, to say that the search is unreasonable, and they meet that when they say there's not a warrant. And so that's why this burden immediately switches to the state, to say that there was not a warrant, but this is why we had reasonable suspicion to detain them. But I think the standing question is, there's evidence, and I would say, it's because it was not raised by either party, but there was evidence that he had standing and he had an interest because he was held there. And we may disagree
That's really what I'm asking.
Yes.
I'm trying to, let's boil it down. What are the things that we can look at in this record to decide that he was held? Well, number one, the car he was driving in was stopped, right?
Yes.
Number two, the officer wasn't going to let that car leave for some period of time because he wanted a drug dog to come.
Right.
Number three, the officer asked him some questions. Well, officers are, generally speaking, take it outside the context of the situation, officers are allowed to ask questions of people just like anybody else can, right? So that doesn't necessarily lead to the conclusion that he was detained because he asked the questions. He didn't ever try to walk away. He certainly didn't get on the stand and testify, I felt like I was detained. Do you see what I'm saying? This is what I think you're asking us to drill down on. What are those factors that we can look at in this record that will persuade us that he could not have walked away?
Was that ever an issue? Did the state contest that he was detained?
No, it was just they had reason to detain him. And, Your Honor, I would ask this court to respectfully remember that they ran warrants on him. And they went back and they said, well, we know he doesn't have state warrants, but let's look for local warrants. Let's look for unpaid traffic tickets.
And
they were looking at him.
That was all before they started waiting for the drug dog, though, right?
Yes, it was a dynamic sort of situation. Yeah. And they called the drug dog, I think, they called for it 11 minutes in the search. They didn't give a response till 7 minutes later, and then it took 40 minutes for the drug dog to get there.
Didn't we say in Lewis, and maybe I'm wrong, didn't we say that the relevant question as to whether Mr. Lewis, in that case, had standing was whether the search of the vehicle was combat by exploitation of the appellant's continued detention and removal from the vehicle?
Yes. And I think that this jurisprudence of this court and others are clear that he had a reasonable expectation of privacy and not being detained. Society recognizes that as legitimate and that is reasonable. And the Fourth Amendment is as beautiful today as it was written when it was first written, and it protects citizens. It protects Mr. Pettit, and it's an important case for him and all citizens of Texas.
So the state did not claim in the trial court that he was not detained. They didn't argue that.
No, it was reasonableness.
Thank you.
That can just respectfully pray that this court will reverse the holding of the 12th and send it back for proceedings consistent with this court's opinion.
Thank you, counsel. The case is submitted.
All rise. Oh yay, oh yay, oh yay. The Honorable Court of Federal Appeals now stands